Civil Laws Subcommittee, we're waiting on one more person, so either we get another member here, or one of y'all runs for special election, next meeting. Sure. I have a feeling there's more than one person stuck in court or Congress.
Oh, they said it's gonna be hours and
Oh,
hours.
it's gonna be brutal.
Yeah,
Higher education is also going on in this.
yeah, I got it over there.
Yeah, I wish I could just give you my proxy, but someone down there. They haven't started yet. Yeah, it's an hour after. They changed it from 30 minutes to an hour after. Okay. Session, so it's for higher ed. Okay. Yeah, where is that, by the way? It's right around.
It's right around the corner.
Right back here.
Yeah.
Yeah. Okay, can you give me some guidance here? Mark Bowles keeps.
He wants to carry it over from the understand what you decided.
Yeah, cause I had actually told him, yeah, cause I was getting pushback from the patrons, so I told him no. Alright. Alright, we're good. Do you have bills and comments?
I have 2 bills in commerce and I have 1 in,
Right, obviously,
but they told me that the hours before they get to me at the end.
for commerce, yeah.
I just need to go over and
At higher ed, I'll be there long enough to get, I mean, I gotta run this, so I really gotta stay here.
so I guess when you're ready, we can work it out.
Okay, who else is over there? Amy?
So it's Gonzalez.
Oh, okay, alright.
So you can check it too.
Here's the federal law, by the way. Discriminates against them.
Right, correct. And so I'll just.
I'm good. Don't leave me.
Yeah.
Hey Pete, come on in. You're on this committee?
No, I'm presenting in front of your committee.
Okay.
I'll be happy to present to
I'm
you.
an Army of one. Yeah.
That's right, I got one. Let me vote and we'll tie.
Have a seat. What do you got? I mean,
It's my surrogacy bill,
okay.
surrogacy contracts, no mandatory abortion.
Okay.
I should fly right out of here.
Yeah, we have stuff for abortion, just goes right through. Very controversial. All right. I'm just trying to get a quorum.
I can see that you don't quite have. You have commerce and labor people.
I know I've got people stuck there.
Who
Who
else
else
is
is on
on
this?
this?
Senator McClellan might be the best bet. He's one that's not on ours.
McClellan, Chapin's here. Is Okeechobee?
Overchain is on ours. Senator McClellan is not. She might be your best bet.
McClellan is not.
Yeah, she
So
might
we
be your
need to
best
get
bet to
her.
try to get her.
How about Louise?
I'll post
She's on our-
Senator Lucas and Senator
Come on in.
All right.
Yeah, I just need someone just to show me, give us a proxy. We reach out.
So we got an announcement here.
I do.
And that's good for mama.
That's what we're gonna relate today. Is that commerce and labor? That's what we're talking about, man. The what?
They're doing that first. Yeah. They're both in balance
All right, let me text Open Chain.
He's
asking
speaking
questions
intelligently
right now.
I forgot.
Senator Lucas is on the way.
Okay. Okay, Jen, I'm gonna tell,
After Senator Pete finishes up, I can talk to him. Assuming we're not these bills. He's got something for these bills, so once that conversation wraps up,
The
he
accounts.
should be able to have them.
Someone just said a week's thing right up there. Okay. All right, I'm gonna call this meeting to order, the Civil Laws Subcommittee. Take the roll, please.
Senator Peterson,
Here.
Senator Lucas, Senator Normand, Senator Obashay.
Here.
Senator Chafin.
Here.
Senator McClellan, Senator Boysko.
Here.
Chairman, you have a quorum.
Great, thank you. Okay, we have a quorum, and so we're gonna start motoring through. You may see bodies come and go, because there's a lot of other committees meeting, but I promise you, we're gonna get through this docket, okay? I see one patron present, and that is Senator Peak.
All right.
Go ahead, sir.
Good afternoon, Mr. Chairman and members of the committee. This is a very simple bill, Senate Bill 920, a one-sentence amendment to Section 2163, which covers surrogacy contracts. And all this says is that surrogacy contracts cannot mandate that the surrogate mother have an abortion or selective reduction. And everybody was here last year, we argued it on the floor of the Senate, it was an amendment to the surrogacy contract bill. And many public policies behind it, but I would just say, these contracts, many of them are really contracts of adhesion. Someone is getting paid to carry children for
Right.
Someone else. They are most of the time doing it for money. They are pregnant, they are carrying the babies, and then someone who is not pregnant, who is not carrying the babies under these contracts can order them to undergo selective reduction or an abortion if they don't like the sex of the children or the number of the children that for whatever reason that person deems fit. So I just think it's against public policy that to have someone in contract, if they can command someone else to undergo this procedure.
Okay, any questions from the panel? I guess I have a question, that is, I mean, it seems like there could be all sorts of different reasons to, I don't know, require an abortion, but if you find out the child has Downs or something like that, or the other one, obviously, if it's a gender-based thing, that to me would be pretty hard to justify. I mean, it'd be pretty hard to justify probably regardless, but, I mean, just walk me through, because typically, if I have a contract with someone to have a child for me,
And then you, in those contracts frequently have the provision that if I deem that I can force you will agree to undergo a selective reduction if there are too many. Let's say there are 3, they can say go down to 2. If there are 2, they say, yeah, let's just cut it down to 1.
Right.
If there's there's no provision if it's 2 girls, you know, I don't feel like girls right now. I was really hoping for a boy. Let's just do away with both of them. And so the contracting party, under those contracts, has that right, the way it is now.
So, Mr. Chairman,
go ahead.
so this is a freedom of choice bill for the
Absolutely,
surrogate?
for the surrogate mother.
Okay.
Mr. Chairman.
Yes, ma'am, go ahead.
So there's no requirement that they carry them all to term, however. So if there are 8 or 9,
Well, they don't,
they're not, there's nothing that prohibits them from,
That's an excellent point.
well, you see,
yeah.
well, I just say medically, they don't do that anymore. They will not put in more than 4.
But, Mr. Chairman,
Yep, Senator Obenshain.
I don't think you, I mean, constitutionally, in current state, the law, I don't think you can do that, right? I mean, you can't take away the choice from the surrogate. I mean,
Well, if you said, for example, well, I'm willing to pay you $20,000 to carry my child, but there's a certain conditions apply, and one is, if they're twins, you have to reduce one, or you have to, you know, or you have to take them both to term, otherwise you're gonna forfeit your $20,000. Would that be enforceable?
They could all be enforceable, yes, that's the question, and they shouldn't be enforceable under the contract. Contract says, I reserve the right to have a reduction, whatever, or abort if I so deem. So it turns out that that one embryo takes, they discover that embryo has Downs, and the surrogate payers tell the surrogate mother, well, we don't want a child with Downs, and I want you to have an abortion.
Right. I guess, and
And so this would say that that's against public policy, which it should be.
what would you think if we made this basically a bilateral, something along the lines of any contract provision requiring an abortion or selective reduction or prohibiting an abortion if legally justified is against the public policy of the Commonwealth? That way at least it reads
Yeah.
equally.
Anything that, I think I would make some of that, because I don't want it to be in these contracts that they can mandate that the mother have it. And if the mother, certainly if the mother is carrying twins and the doctor says you've got preeclampsia and you're gonna die if you carry both twins.
Right, that's, yeah.
Then the contractor can say you're gonna die, so I don't have a problem with that.
All right, I think that to me at least adds some symmetry to it.
Could you repeat your?
Okay, so it'd be any contract provision requiring an abortion or selective reduction or prohibiting abortion if legally justified is against the public policy of the Commonwealth.
I think, I would say that I have a problem with legally justified, because that's narrowing it in, and that's saying,
Requiring or prohibiting an abortion.
I don't know.
Or just say an abortion
It'd be actually,
as.
it'd be medically, if medically justified, I
All right,
guess.
yeah, forget the word legal. Or just, you know what, just say or prohibiting an abortion. We'll just leave it at
That is fine with me, I just would like to have it in those contracts, cannot
Or
mandate,
prohibiting an abortion.
requiring or prohibiting.
Okay, let me see, do we have any witnesses to testify on this bill?
Yes.
Come on forward.
Mr. Chairman, Subcommittee members, Josh Hetzler with the Family Foundation. As amended, I don't think we would have a problem with that. I think it would, to Senator Obenshain's point, I think you wouldn't be able to prevent a woman from having an abortion anyway, probably under any circumstance. I think that's already the constitutional standard. To that extent, we're not bothered by that. What we wanna make sure of is that no one is forced to have an abortion against their will. We do know that these contracts are on the rise. We know there's been several high-profile cases where this has become an issue. Several law review articles written about it. What do we do about this? It is becoming a real thing, and so we want to
Okay.
just make sure that it's.
I would simply say, I don't think anyone would get forced as in like physically forced. I think what would happen is they would forfeit their monetary consideration. You think they could be physically
Well,
forced?
I don't know, I mean, it's not
I
their,
don't know about that.
it's not their.
Another.
All right, we have another
I mean,
witness. Let's get to that. Yes, ma'am.
Yes, Senators. My name is Olivia Turner. I'm the president of the Virginia Society of Human Life. We have a long-standing concern with this aspect of the surrogacy law in Virginia because unfortunately there does appear to be evidence from other states where coercion has actually been involved in some of these cases. I'm not aware of any coercion officially in any case here in Virginia, but the entire concept that the Commonwealth of Virginia could be, in fact, in the situation where we are contractually requiring that an abortion could occur is of great concern. That the abortion could be required by the couple working with the surrogate mother because of either sex or number of pregnancies involved, or perhaps the health of one of the babies in the condition of pregnancy that we're talking about, all of which gives us concern. So because we know other states are facing issues where coercion has been involved, either
Yeah.
legal coercion or medical coercion, and because we do understand that these babies, all of them, need to be protected, and this woman should never feel that the Commonwealth of Virginia would oblige her to have an abortion. That's our
Senator
main
Boyce.
concern.
So I just question
Yes,
you,
Senator.
there is no current problem in Virginia?
I would not say that, Senator. I said I am personally aware of cases in other states where this has occurred. I am not
You're
suggesting that it could not be happening here
But it
or
is
has
not.
not been.
Is not.
I am not saying that I know that to be true, Senator.
No current lawsuit. Mr. Chair?
Yeah, go ahead, Senator.
And just to add, and so what could happen? Why I think it needs to be in this, because it is a contract. So the situation that I see is the mother is pregnant with three, the surrogate mother has 3 children or 2, and the surrogate, and she's got a contract, pays her for successful delivery of the children. And they said, no, I want you to cut it down to 1 or 2, whatever the case may be. She doesn't do it, and then at the end, you breached the contract. I told you to do this, I'm not gonna pay you. And that's where it comes in, and so they'll use that, and you breach the contract. So that that portion of the contract is against public policy.
Senator Boyce, go.
So another question, just getting technical here, is this her DNA and her husband's DNA? Are these her eggs?
Usually,
Or is this a donor's,
Mr. Chair, and
Go ahead.
most of these are someone else's. Yeah. So you have 2 men who wanna have a child, or a couple who cannot have children. They get the eggs, whatever. Sometimes maybe 2 women. Well, no, they don't need to do it. It'd be 2 men, excuse me, yeah, 2 men.
Theoretically, they
Someone
can.
else, someone who can't have children, they may get them somewhere else.
Somebody
And
else
somebody
will figure it
agrees to carry them. And it may be that they're carrying half of the other person.
Right.
It could be hers, it could be any of those. There's no limit on the scenarios.
All right.
That's what it could be.
Anybody speaking in opposition? Okay, what I would suggest is, again, I'm just, I understand what you're getting at, and I pretty much agree with you. I think though, in order for it to be a statement of the policy, I think we'd have to either say requiring or prohibiting an abortion.
That is,
Is against the public policy of the Commonwealth.
and
Selective reduction is not a defined term, so I mean, I know what you're saying, but a judge may not. So I would suggest that amendment.
I would accept that.
Okay.
I'll move the amendment.
Is there a second? I'll second.
Second.
All right, all in favor say aye.
Aye.
All right, the bill is before us. Okay, got a motion to report. Do I have a second?
Second.
I'm gonna vote no,
Recommend.
Okay,
it's
we're gonna
just,
vote.
I'm not comfortable with it.
Fair enough. Okay, all in favor say aye.
Aye.
No.
Okay, we got 1 no.
Thank you, Mr. Chair.
Yep, you got it. Okay, do we have any other sponsors? Senator Cosgrove.
Yes, sir, Mr. Chairman, how you doing?
I'm doing well.
Good.
I have a Senate Bill 967. Your pleasure. Mr. Chairman, this bill deals with eminent domain. We passed some eminent domain bills a few years ago. I have Mr. Joshua Baker. Is he, Josh, you here?
Josh, you're come forward.
Yeah. If it'd be okay with you, since I'm not an attorney, I would like to let him speak to the bill
Okay.
a little more intelligently than I can do.
Okay.
And I will tell you that the Attorney General has some amendments he wants to add. to
Okay,
the
why
bill.
don't you get to the bill and then we'll talk amendments. So, Josh?
Thank you, Mr.
Go
Chairman,
ahead.
Senators. This bill would require that a certain letter that is provided to property owners right before their property is to be taken by a certificate would actually tell them the number of days during which that is going to occur. The code currently says, and I think this may have been Senator Obenshain's bill from a couple of years ago, that owners would be given a 30 to 45 day notice of when this is going to occur. What's occurring right now is that the letter that comes just makes reference to the code section. Owners have no idea what that code section means. This bill would allow, or would require that those letters specifically state that in 30 to 45 days, the certificate will be recorded at the courthouse.
Okay.
We're aware of the Attorney General's amendments and have no problem with those.
Okay, can I get my phone number stuck in there too?
Only if they give them mine too.
Okay. South of the James. Okay, all right. Is somebody here from the AG's office that has an amendment? Going once.
Mr. Chairman, I can tell you what.
Do you have?
All right, well, if you have it, go ahead and tell it to us.
Yes, sir. I'm sorry, I don't have the PDF file. For the line numbers, kind of.
Josh has. Senator, I believe I have them.
Okay.
If
Okay.
proper, I have it. It'd be line 18, and the Attorney General would like to strike ownership of, and
Line
replace
18. Such notice shall state that upon recordation certificate, strike the property shall transfer. Okay.
Actually, no, sir.
Ownership of.
It strikes ownership of
Yes.
and replace it with the defeasible title to property.
The defeasible
Yeah.
title to the property. Okay, shall transfer. Okay, what's the next one?
The second amendment is, right up that line, is, replace take possession,
Yep.
right before funds, and replace with for distribution.
Shall petition the court for distribution.
Yes, sir.
Yes.
For distribution. Okay, of the funds represented by the certificate.
Those are the, two amendments requested by the Attorney General's office. We're fine with those.
Okay,
amendments.
all right. Anyone move those amendments? Senator Chapin?
I'll move.
Second.
Second.
All in favor say aye.
Aye.
The amendments are added. Okay, anybody else either in favor or opposition to this bill? Senate Bill 967. All right, I'll entertain a motion.
Move to recommend reporting.
All right, all right. Moved and seconded to report 967. All in favor say aye.
Aye.
Opposed?
That was the least painful
Good work.
course, anything I've ever read
Good
through.
work.
Thank you, Mr.
Good
Chairman.
work. We're getting soft. Okay. All
I
right.
don't think that's the case. Thank you.
Okay. Anybody else who's outside the family here? Okay. Otherwise, Josh, while we're here, do you wanna go to our other condemnation?
I'm happy to have a committee look at it. Sure.
All right, let me, Senator Hovenshade, do you have a condemnation bill?
I do. Is it on the docket today?
Otherwise,
951.
what's that, 551?
951.
951, go ahead. Senate Bill 951, written offer to purchase property.
Josh, you want to step up?
951.
I'll let Josh explain this. Yeah, so the issue that this addresses is this is a different letter that the condemnors are required to send out. That is the offer letter when they are going to condemn property. It's a different letter than what you just dealt with. This is on the very front end of these cases. And what typically is happening, and it just kind of varies depending on who it is that may be taking your property, but there are companies that are contracted, these right-of-way companies, and very often owners are receiving a letter on the contractor's letterhead, not on VDOT's letterhead, telling them, we're going to take your property at VDOT's request. There are some issues, frankly, I think with senior scam type things and just making sure that when the government or the utility who is carrying the power of eminent domain is going to take your property, that is officially notified.
So in other words, it would be the right-of-way agent.
Wouldn't be the right-of-way agent, it wouldn't be any of these companies.
Correct. All right, so this is pretty simple, just when the formal offer is made to purchase the property, it has to be on the VDOT, the letterhead of VDOT or I guess the local, the county.
Correct.
Okay.
Or the utility for that matter. But they don't.
This just says state agency's letterhead.
The state agency is defined at 25-1-100 to include the Commonwealth, the municipalities, and the utilities who are delegated the power of eminent domain.
Okay, very good. Got all the answers. Okay. Anyone want to speak on Senate Bill 951? Silence. Okay.
Move to recommend reporting.
All right.
Second?
All right. Been moved and seconded to report 951. All in favor say aye.
Aye.
Aye. Any opposed? Okay, Josh, next up, I know I've got a couple for you. Let's try Senate Bill 28. And Senate Bill 28, which is my bill, is a bill that we had last year.
Uh-oh.
Let me just put my reading glasses on. Okay, I think this has to do with taxable costs.
28?
Yeah.
Yes.
Okay. Senate Bill 28 is a bill that basically levels the playing field, where it deals with taxable costs in a condemnation proceeding, where if your property is taken by a state agency previously, and you litigate and you win, then the court may order the condemnor to pay reasonable costs other than attorney's fees, including a reasonable appraisal cost. So if you had to pay an expert to value the land, you're allowed to get reimbursed those expenses, which makes sense because you've had to go to court and essentially protect your land. That provision does not apply to public service companies, public service corporations, railroads, or government utilities, which I've never understood why they basically get a better break than the government. So my bill strikes that requirement. Before I give Mr. Rust the opposing viewpoint, Josh, you want to speak to it?
I'm happy to. Yeah, this does follow a reform of 3 or 4 years ago that changed the perspective of how an owner would be qualified for reimbursement. The utility companies at that point were able to cut a deal to not be put under that requirement.
Right.
And in short, what that does is it changed the point at which the reimbursement qualification for an owner is triggered. The old law and what the utilities are still under is a scenario in which you have to beat their final offer made to you before trial by 30%. The law that applies to everyone else is what common sense folks would say is what they base their decision to go to litigation on. That'd be the first offer. And so this just brings them into the fold and creates, as you say, a more level playing field, no matter who's
Okay.
taking your property.
Mr. Rust?
Mr. Chairman, this is Baker, and I've had a chance to talk about this.
Sure.
I think we've got a relative agreement on what we do.
Okay.
There were amendments that were allowed last year that we were dealing with the bill, and the major question.
Have a seat. if you
Sure.
will. Yep, take your time.
The principal question that we're dealing with is how do we deal with small utility condemnations from the linear right-of-way that they're taking that doesn't have a lot of value in it.
Okay.
What this would do is restore the exemption for condemnations under $10,000, so that if you had a small condemnation, you're not subject to all the assessments and other things that the statute requires. We also provided an amendment which would make this applicable prospectively. So if you already had a condemnation going on, you would not look back to the change. You would work under the other system as you went forward. I think Mr. Baker has no objection to either of those amendments.
Josh, you okay with those amendments?
I think we're gonna be okay with that.
Okay, so I wanna make sure I got these just so oh, there we go. So basically, this would be limited to those condemnation actions initiated,
July 1 of this year.
okay, where does it say July 1?
That's on the next amendment.
Oh, Alright, after, after July 1, 2020, and would not apply to those easements. In other words, the carve out is for those easements valued at less than $10,000.
And I think everyone's understanding is that is an ultimate determination of value,
Right.
not an offer.
The 10,000 would be the ultimate,
Right.
the ultimate, in fact, I'm gonna put the words ultimately, or should I put adjudged?
Well, this is the statutory language, it's been in existence for a number of years, I think it's already being applied that way.
Okay.
I don't think there's any disagreement among us on what happens there. You got a condemnation that's $12,000.
My worry is that this is
I'm never
value.
upset by clarity.
Yeah, I'm never, if you say valued, it'd be a question, but I would say adjudged.
I'm fine with
Because
that.
I think that at least makes it clear that if you get a court ruling. Okay, so we have two amendments here, one which makes it, this is prospective from July 1, 2020, and the second one that says, the carve out for the utilities remains for those easements that are adjudged at less than $10,000. In other words, the small linear easements. Okay, do I have a motion to accept those amendments?
So moved.
Okay, all right. All in favor say aye.
Aye.
Any opposed? All right, bills before us?
Second.
Okay. All in favor of reporting say aye.
Aye.
There we go.
Thanks.
Good work, okay. The other one I had was Senate Bill 30. Yes, oh, Bill.
Sure.
Okay. Actually, let me do Senate Bill 31, and then I'll get to you in just a second. Senate Bill 31, and Jack, you may not want to leave
Yes,
yet.
sir.
He does.
Senate Bill 31 has to do with filing fees for drawdown petitions. And for those of you who don't understand what a drawdown petition, when the government condemns your land or a utility company condemns, well, typically government condemns your land, they'll pay money into the court, and then you have to file what's called a drawdown petition as the owner of the land in order to claim the money, even though it's legally yours. What this bill does is that it basically says there is no filing fee for those civil actions. One of the amendments I need to make to the existing text is where it says, including the release of any liens attached to the funds. I talked to VDOT, and I just need to strike that language, because that's really something different. So I'm gonna move to strike that language if I can get a second.
Second.
Okay. All in favor of that amendment, say aye.
Aye.
And then that will be, yeah, go ahead,
It
Joe.
needs to make sure that you're not, that we're not putting anybody under an obligation to pay the lien itself, but the cost of getting the release.
Right, but
That should still be covered, and I don't know, Senator, if your amendment necessarily meets that in bounds.
okay, well, I had already talked to VDOT and told them I was gonna make that amendment, and I made a similar amendment last year. So that leaves the text being, any costs of filing such petition or otherwise withdrawing the funds shall be taxed against the condemned. That's the bill as it is right now. Okay, Josh, do you have anything you wanna say in support on behalf of the, landowners community?
I think you've described that very well. And this is a cost that owners are essentially being charged to withdraw money from the court that's there on their behalf, so.
Okay, Senate Bill 31, anyone opposed to the bill?
I have a request for a change, and I'm not opposed to the bill.
Okay.
Again, last year, we basically said, let's make this perspective. You've got a change in interest rate and a change in how costs are allocated.
Right.
So do it on condemnations after July 1 of 2020. And here's an amendment that would do that.
All right,
And I don't
man.
know whether Ms. Baker has any objection to it.
All right, so this would make these amendments prospective to July 1, 2020, after July 1, 2020.
I'll move it.
Okay, all right, all in favor say aye.
Aye.
No objections, any objections? No objections, because I'm the only other person here. Okay, all right, so now we have the bill in front of us with the text and the amendments.
Your amendment also needs to be made on page 2, lines 77 through 78.
Okay, all right, so,
I'll move that amendment.
all right, second that, all in favor of that amendment on 77, 78, say aye.
Aye.
Okay, any opposed? All right, so that passes also. So now I think we've got this in good shape on Senate Bill 31. Can I get a motion?
Move to report.
Second.
Mr. Finance has asked for this one.
Really?
And re-refer to finance.
All right, I moved, we have a motion and a second to report or refer this,
Yeah, just
bill to
only-
finance. All in favor, say
Yeah.
aye.
Permits are
Any
not just
opposed?
speaking.
Off it goes. But I get to keep this forward, right? Okay.
Thanks, Mr. Chairman.
Yep, thank you, Jack. Okay, Bill, Senator Steph.
Thank you, sir. Mr. Chairman, members of, Josh, thanks. Mr. Chairman, members of the committee, you have Senate Bill 485. Just make sure, 485, eminent domain. And Mr. Chairman, what this does is it repeals the provision of the Code of Virginia declaring that the acquisition of residual parcels when acquiring land for highways, right-of-ways in the public interest and public use. The bill provides a property owner with the ability to decide whether acquisition would create an uneconomic remnant or whether the damage to the remainder of the piece of property acquired would equal or exceed fair market value on the remaining land. And I'm gonna go through one example that was a personal example, but since I was on city council, I couldn't do anything about it.
Okay.
I had a duplex lot on one of our main roads, Prince Sand Road down there. When they originally were going to take 50 feet for right-of-way on one of the roads, then they came back and took 150 feet. So it made a huge difference in it, but I had already built it. At the time, I was offered $10,000 for the 50 feet. When they took 150 feet, they wanted to either take the entire piece of property or provide me $10,000. I had just put in a $700,000 duplex. I wasn't about to let them take the property for $200,000 and be that much underwater. So I ended up taking, on that piece of property, $10,000 for 150 feet, which completely eliminated the front lawn and left me with about 20 feet of front lawn and about 50 feet of back lawn. There's a couple of other examples, and I'm gonna turn it over to Josh for those, and then to explain this a little bit more.
Okay, well, this bill basically gives you the option to keep the residue or reject it, right?
Correct, that's
Okay.
correct, Mr. Chairman.
All right, Josh, go ahead.
That's correct. I believe there's a substitute.
Oh yeah, we do have a substitute,
Okay.
And then on that substitute, we have a line amendment that changes 4 shalls to mays when we're referring to the courts.
It just, for additional context, this does occur. We recently had a landowner who had a very small part of their building that was actually gonna be impacted by the taking. They were okay and understood that the building needed to be taken, but they didn't think that the balance of their several acre lot also needed to be taken. They objected to that. This was not VDOT, this is a locality engaged in this case. They were told, no, we're gonna take the whole thing. As a result, basically going all the way through trial and being on appeal, things got worked out back so that the city involved did honor that owner's request. The substitute that we have worked out with other stakeholders, VDOT I believe is here. We met earlier today for some additional things. I think everybody is now, if not in favor, at least neutral as to the substitute. And then I do have the line amendments that I'm happy to.
Okay, walk me through the substitute, because I feel like you've taken a very simple concept, and I congratulate Senator DeStefan and made it about 20 times more complicated.
Yeah, so basically the only voice that matters under the current code is the condemning authority, and they have full say
Right.
whether they're gonna take the whole property or not. What the original bill did was just shifted that so that the owner could speak and be the one to make that determination, being the one we think in a better position to make that.
Right.
What the substitute does is strikes a balance so that if there is agreement between both sides, then it'll move forward as they've agreed. If after they have made an effort to try and reach that agreement, there is none, it provides for the court to make that determination before the case moves forward for the condemnation. This won't impede any construction, this won't have an effect on any project schedules, because the only part that will be used for construction is by definition not the uneconomic remnant. So again, Senator, I think all, and VDOT is here as well, and Richie Stewart, I believe, is available to speak to it.
Okay, yeah, go ahead.
Okay, Mr. Chairman, Senators, I'm Richie Stewart with VDOT, and thank you for having me here.
Right.
And I'd also like to thank Senator Steph and Mr. Baker for working with us on this bill. While we haven't received a position from the governor as of yet on this, we've looked over the bill, and what Senator Steph and Mr. Baker have done have allayed most of our concerns, and we feel very strongly that.
Okay. Here's my question. This language is a little more complicated than it needs to be. Let's say hypothetically, I represent a car wash along Route 1, and VDOT's taking the front of the parking lot. And I say, you know what, this is gonna have to close, so you really need to take the whole property. We would then litigate that separately before we litigate because now it would be sort of wrapped into the whole trial. I mean, how's this gonna work? We're gonna have 2 trials instead of 1 trial?
That is my understanding from the bill.
Josh?
Yeah, if they don't agree to take the whole thing, and you think that it should be, I think you'd have an option, actually, Senator, that you could exercise this procedure to get a determination, a court determination prior to your just compensation trial, that they have to take the whole. Or you could proceed to trial and say it's a total loss and have the jury make that decision. I think you'd have the option.
All right, well, let's look at lines 139 through 142. If the acquisition of only part of the property causes an owner or condemned owner to believe the remaining property is an uneconomic remnant, and I don't know why it says, and there is disagreement. Of course there's gonna be disagreement. I mean, VDOT's already saying that. So I would say the court shall determine the issue on the petition of either party and upon the presentation of evidence. And then there seems like the next sentence is duplicative. Should you say the court may determine the issue on the petition of either party and upon the presentation of evidence prior to the setting of the matter for trial?
I think
Is
that's
that
fine. You could say may.
Yeah, let's do that. Let's change that shall to a may. And then what I'd like to do also is, I would strike the second unless the parties agree otherwise. The court shall, I mean, I think you can essentially combine those 2 sentences. So,
How much of 141? I'm sorry.
yeah, let me just read what I think this should say. If the acquisition of only part of the property causes an owner or condemned owner to believe that the property is an uneconomic remnant, comma, the court may determine the issue on petition of either party and upon the presentation of evidence, period. Comma, prior to the setting of the matter for trial and just compensation. I think that's what you're trying to say. Right?
Yeah, I think that's okay.
I think the rest of this is somewhat duplicative, it's gonna be confusing. But I think that may is important, because I think that should be an option for either party, I don't think it should be forced to do it, okay? All right, I'm gonna move that, can I get a second? There we go, all right. All in favor of that amendment, say aye. Aye. Okay, any opposed? All right, other than that, it looks pretty good.
Mr. Chairman, I think on line 178, you also would wanna change that to a may, the court may.
Okay, all right. Okay. All right, I'll move that, second.
And 179.
So, we'll change the shall to a may on 178, 179. All in favor, say aye.
Aye.
Any opposed? All right, so the bill is, 485 is in front of us as amended.
Mr. Chairman, there were a couple of other line items that we discussed with VDOT that I do want to alert the committee to.
Okay.
That'd be on 144, 147, 181, and 184. Those are all shalls to may. All 4 of those.
So from 144 to 188.
It's 140. I'm sorry, 140.
We already did 141.
Yep, 144, 147, 181, 184.
Okay. So all those shalls are being changed to mays.
Correct.
And that will match this up. Okay. All right, I will move and Senator Lucas will second that we're gonna change those shalls to a may as articulated, by the patron. Okay, all in favor say aye. Aye. Any opposed? Okay, okay, did you get all these edits, by the way?
Yes, I did.
Okay.
I'll
very
run
good.
it by Josh, so.
Okay, all right. All right, good work. Anyone want to speak on this bill that hasn't been spoken yet? Okay. All right, can I have a motion to report? All right, I'll second. All in favor, say aye.
Aye.
Any opposed? Okay, 485 reports, good work.
Thank you very much, Mr. Chairman, members of the committee, have a great day.
Yep. Okay. All right, what other, do we have, Jennifer, do you have any bills?
I've got your.
You got it.
Yeah,
Okay.
thank you.
Okay, Open, you got any bills?
I do.
Go ahead, what else you got?
I have Mark Fix here on the abolition of interfamily immunity
Okay.
for wrongful death actions. Mark, you want to come up? We had a witness who was unable to be here, who had a case that I think really highlights some of the need to make this change. Mark.
Thank you, Mr. Chairman, members of the subcommittee. Mark
Yep.
Fix on behalf of the
Come on
Virginia
up, Mark.
Trial Lawyers Association. We appreciate Senator Obenshain bringing this piece of legislation forward. So Virginia is in the minority of jurisdiction that still recognizes the intrafamily immunity doctrine with such sweeping breadth. And what that does is it prevents the estate of a deceased unemancipated minor from bringing a cause of action against the parent that is responsible for their death.
What's the number on this, by the way?
693.
693, folks.
The Virginia Supreme Court has carved out a few exceptions to that, one that deals with motor vehicles, intentional conduct, and then if it's within the scope of a business relationship, such as I think it was the dad was a driver. But other than that, the intrafamily immunity doctrine is still an absolute bar. So it's kind of a strange situation where you could have a dad who's driving a child to the river and gets into a car accident and causes death, and there is recovery, but if they go to
And it's important to point out that, I mean, we're talking about the estate of the child making the recovery, so typically it would not be the dad whose negligence was responsible for the death of the child qualifying as the executor or the administrator of the estate. It'd probably be the mom or a sibling or somebody, and the court ultimately anyway has authority to make an allocation of the recovery in a wrongful death action. So if dad's negligence was responsible for the death, the court already, or jury already has the ability to say you get nothing from this award. I'm sorry to interrupt, Mark.
Okay.
And keep going.
Yeah, so Mr. Chairman, my witness that was going to be here today, at her firm, I think they've had 3 or 4 different cases, and it seems to arise a lot with unwed parents, where the one parent has the child in custody, and it seems to be a lot of drowning type of incidents, and there's really no recovery that can be had, again, because of this absolute immunity. And so the bill would seek to correct that and bring us more in line with other jurisdictions.
Okay, I got a question. What happens if I've got a situation, you know, we talked about hunting accidents, but it doesn't have to be hunting, it could be, you know, I take my son on some type of nature, you know, we go hiking, and I don't monitor him like I should, and he gets lost and he dies of exposure. Now that's negligence, it's not a manslaughter, there's not gonna be any, you know, dead, Slayer statute. Am I allowed to make a claim, can my wife make a claim against me for not monitoring him properly?
Mr. Chair, I believe that, yes, the mother would be able, on behalf of the estate of the deceased child, be able to make a claim against the parent who was responsible for the wrongful death of that child.
Under this statute.
Mr. Chairman, that's
Yeah,
correct.
they could make a claim, they
Correct.
couldn't before.
They could not before.
Correct.
Okay, I mean, what, take out the wrongful death part, let's just say it's an injury. Let's say I let my kid, you know, roughhouse in the house and one of them gets injured and, hey, I should have been watching them more closely, and now I get someone else to pay the medical bills.
Mr. Chairman, that's why we restricted it to wrongful death, just the most
All right.
egregious.
And to put a finer point on it, what we're talking about, I mean, the more common situation would be 2 parents are not married, and one takes a child, negligently
Gotcha.
allows the child to wander off, and the other one's you know, left with no recovery because irresponsible parent allowed the child to die while in the other parent's custody.
Yeah, I still think you're gonna have some issues if it's a death by negligence. Obviously, if it's by manslaughter or homicide, then you got Slayer statutes protect you.
But we've already crossed that bridge with respect to motor vehicles,
Yeah.
and said if there's a motor vehicle collision, and I'll tell you, in motor vehicle cases, I see insurance companies here and want to hear from them. You know, there's insurance in most of those cases. In these drowning cases, you know, there's often no insurance even out there. So, you know, it is something that you know, every once in a while, you wind up taking a case that just is important to help somebody. And even if there's not maybe gonna be a recovery. And I think in a lot of these cases, you're gonna have a lawyer who's just trying to help somebody get a judgment, to make a statement, to provide that if someday somebody ever comes into any money, we can enforce this judgment.
Okay, anyone here to testify in favor or opposition to Senate Bill 693? Chris? What does that mean?
We're good.
Safe at home?
No, we're good.
There's no insurance.
And you said no insurance, okay, you're not gonna be covered anyway, Jeff, good luck, okay.
Mr. Chairman.
Yeah.
So, because we have, abrogated this and done away with it with regard to automobile accidents, it seems fair to look at it in the broader sense. And I mean, there's just a myriad of circumstances that can occur where one parent is irresponsible or negligent, without meaning to be.
Sure.
And it results in the death of a child. And there may or may not be a way to recover some monies, but I believe that the time is here for us to abolish this practice.
And it's a limited repeal of it.
Yeah, it
It's
is.
just for wrongful death.
Yeah, this is not limited solely to children, though, this could also be if a spouse dies or disappears and the estate sues the other spouse, right? Like a Natalie Wood situation.
But you've got to prove your case.
Mr. Chairman, the inter-family immunity doctrine only applies to claims on behalf of unemancipated minors.
All right, well, there you go, okay. All right, I think that's helpful. Any other questions from the panel? All right.
Second.
All right, all in favor, I'm gonna stay in at this just because I wanna do a little bit
Why
more.
don't you make me talk?
Yeah, okay. All in favor, say aye.
Aye.
Abstain. Okay, good work. Okay, Ben, before you got your bill, let me do my mechanics lien bill, because I know I've got some folks here on that. This is Senate Bill 208, mechanics liens and right to withhold payment. Fred, bring them forward. And, well, Fred Cotting's coming forward, he's a lawyer in Fairfax City, longtime friend. Basically, this bill has to do with subcontractors who are effectively cheated out of their money because the general contractor is paid fully by the owner, which means that you can't put a mechanics lien on the property, but the general contractor, rather than paying the sub, spends money on another project or runs off to the Bahamas or what have you. So what this would do is give you a civil cause of action against the general contractor or subcontractors. You can go against them directly, without, again, when you don't have the ability to put on mechanics lien to get paid by the owner. So any contractual provision that would prevent you from filing suit in order to collect your money in this situation, we declare void. We've done this before. A few years ago, we had a similar bill which basically said that you can't give up your right to mechanics liens if you're a sub, and so this is really just a continuation of that. So, Fred, I've prepped it, but other than that, go ahead and speak.
I have a handout for members of the committee. Mr. Chairman and committee members, as Job indicated, I'm Fred Cotting, Fairfax, Virginia. I'm here on behalf of the Iron Workers Employers Association, as well as the organizations which are listed on the page 2 of the handout. Those organizations and their members have projects throughout the Commonwealth, and members of the Iron Workers Association in particular, they supply the reinforcing steel, the structural steel, the window wall, the curtain wall on projects throughout the Commonwealth. When they finish a particular project, they should be paid for the labor and supplies that they have done on that project. That particular project should be paid for. General contractors at times offset payments for that project for some other project's alleged claims. The talking points you received discuss the issue in detail. Payment on completed Virginia projects should not be withheld because of some dispute on a totally unrelated project. That dispute could be even on a project in North Carolina, Tennessee, West Virginia, Maryland, and even the District of Columbia. Such offsets have been barred and banned in other jurisdictions. Examples are Texas, Oklahoma, South Carolina, and Maryland. SB 208 remedies that unfairness. It helps the small businesses and the small contractors, the subcontractors, and the suppliers. Some may say this is simply a contractual matter. As Chap mentioned, several years ago, there was a bill passed by this General Assembly which barred the enforcement of contract provisions, which barred the assertion of bond claims or mechanics liens. Ironically, AGC opposed that legislation initially, but they came back the next year or so, and they sought and obtained the same protection for their smaller general contractors. We request your support of SB 208.
Anyone here to speak in support of Senate Bill 208? Yes, sir.
I'm Jay Atkinson with the Alliance for Construction Excellence. I'm also part owner of Cheney Wilmer Electrical Contractors here in Richmond. We do a large amount of work for the state, VCU, University of Virginia, different areas. You have to go through a process every month to get paid. Lien waivers, conditional lien waivers, all of that. And at the end, that's how the general contractor gets paid for that portion of the work. And we would like to ask for your support to make sure that those monies from that owner come back to the contractors on that job site. And the provision to remove the right of refusal should be, we would ask for your support.
Okay.
Those, like Mr. Rowe said, you go through a painful process to prove where you are in order for the owner to pay the general contractor. That money should stay within the project.
Yes, ma'am.
My name is Patty Peterson, and I'm from New Kent County. I am here on behalf of ASA, American Subcontractors Association, but also am a subcontractor, Timber Corporation in Petersburg. We also, big subcontractor, supply a lot of buildings throughout the Commonwealth. Believe that every contract should be standalone. It's on that project only. This being able to trickle in and look at other projects and seeing if there's a problem and hold their funds for that you've paid the general contractor for this project can hold funds because they believe they have a problem on another contract, that isn't right. We have divisions throughout all of the southeast, spanning from Texas to Virginia. So what that's saying is they could use the funds being paid for a project here in Virginia to pay a project they believe they have a problem with in Georgia or Texas. They need to stand alone. The contract is for this project. It's too far reaching when it can pull funds from other projects for perceived problems.
Thank you, Ms. Peterson. All right, Ben.
Ben Dendy with Vector Corporation representing Titan America. Titan America is headquartered in Norfolk, is in the ready mix business in Northern Virginia, Richmond and Hampton Roads, and owns the state's only cement plant, Roanoke Cement, in Botetourt County. Doug Strobel is director of credit for Titan America, is here in support of